Ready? Exercise number 16, Series B, Legal Matter. Start. This special leave petition is against the order dated 27/7/2020 in BA number 4646 of 2020, passed by the High Court of Jharkhand at Ranchi insofar as the petitioner has been granted bail subject inter alia to the condition of deposit of bank guarantee of rupees 53,000 in the trial court. Stop next para. As pointed out by Mr. Rana Mukherjee, a learned senior advocate appearing for the complainant, the impugned order records that the petitioners are now ready and willing to deposit the amount before the trial court. The question is whether bail could have been granted subject to deposit of rupees 53,000. In our view, the High Court erred in making bail conditional upon furnishing of a bank guarantee, which is as good as cash deposit, having regard to the condition usually imposed by banks for issuance of bank guarantee. The complainant has also filed a civil suit for specific performance of an alleged agreement executed by the petitioners for sale of property in Himachal Pradesh, which is pending adjudication. Stop next para. By imposing the condition of furnishing bank guarantee of rupees 53,000, the High Court has, in an application for bail under Section 439 of the Criminal Procedure Code, virtually issued directions in the nature of attachment before judgment in a civil suit, if not recovery of dues without trial. It is well settled by a plethora of decisions of this court that criminal proceedings are not for realization of disputed dues. It is open to a court to grant or refuse the prayer for bail, depending on the facts and circumstances of the particular case. Stop next para. The factors to be taken into consideration while considering an application for bail are the nature of acquisition and the severity of the punishment in the case of conviction. The nature of the materials relied upon by the prosecution, reasonable apprehension of tampering with the witnesses or apprehension of threat to the complainant or the witnesses, reasonable possibility of securing the presence of the accused at the time of trial or the likelihood of his abscondence, character, behavior, and standing of the accused, the larger interest of the public or the state, and similar other considerations. A criminal court exercising jurisdiction to grant bail/anticipatory bail is not expected to act as a recovery agent to realize the dues of the complainant, and that too without any trial. In Shyam Singh versus State through CBI, reported in 2006, 9 SCC 169, on which reliance has been placed on behalf of the petitioner. This court categorically held that it is open to a court to grant or refuse bail, but to say that offence has been committed even at the stage of granting bail and to direct repayment of any amount is both onerous and unwarranted. Stop next para. As held by this court in Anil Mahajan versus Bhor Industries Limited, reported in 2005, 100 SCC 228, the absence of the complaint is to be seen. If criminal proceedings are unwarranted, there can be no question of custody, and in no circumstance can bail be made subject to the terms which tantamount in effect to execution at the inception. Needless to mention that the other conditions shall remain the same. It is made clear that the observations in this order are prima facie observations and will not influence any proceedings in future. Stop. Next para. The special leave petition is disposed of accordingly. Pending applications, if any, shall stand disposed of. Full stop. Thank you very much.